I grew up in the area in Sayreville, born and raised here. I have an office located in South Amboy. I've been practicing for just about 13, 14 years in this area. I've done both the litigation side for several years before I've switched over to the planning side of things. And my experience with the litigation, I see everything that can go wrong. So my goal is always to help my families avoid sort of those pitfalls when we are planning. So I'm going to jump in and get started tonight. I do want to let everybody know that we are recording. To the extent you want to ask questions, please feel free to do so in the chat. I will keep an eye on that as I'm going, and if I can answer them during the presentation, I will certainly do so. But please don't put personal details in there because this is going to be private, publicly posted, and I don't want private information out there about your family or your loved ones. So let's go get started. I'm going to give you an overview of the topics that we are going to cover tonight. Right, so this is just a big broad outline, some broad strokes. Number one, I want to talk about the why and why this planning is so important and why we do that. I'm going to talk about the parts to an estate plan. I'm going to talk about what the documents are that go into it. I'm also going to talk about some other documents and other paperwork. While it might not be a legal or a financial document, it is equally as important as part of this planning. And then I want to talk to you about long-term care planning, right? And touch upon things like the Medicare and the Medicaid, some of the legal aspects of that, maybe long-term care insurance. Now, all of these topics, I want you to realize I'm going to touch the surface on these tonight because all of these are very, very involved. There's a lot of nuances to these different topics. We could do an entire presentation on just one, but we're going to cover the surface so you walk away tonight with a knowledge as to why we do these, what parts are involved, and how we can think about caring and providing for our family member that might need that care, once they start to age. So let's jump right in and talk about that estate plan. Why do we even plan? It's important to know what happens without the plan to really solidify the reasons why we are planning, right? So people pass away and they don't have a will. We're talking about my example I'm going to start with is going to be the death one. If somebody passes away without a will, New Jersey law has what's called an intestacy statute, right? That statute is in place and that decides certain things for that individual and for their family. Those sort of decisions are a couple. Number one, it's who's going to handle their estate. Number two, it's going to cover what happens to their assets that are in the estate, right? So example is if you've passed away without a will, you may not want all of your assets going to your spouse. Let's say you don't have a spouse, you may not necessarily want all of your assets going to a child. In other circumstances, we might have a child who's a minor. We don't necessarily want those assets going to them. Sorry about that. The recording had stopped for a moment, so I just wanted to double check with that. Oftentimes we may not want assets going to a particular person. Maybe we don't like them, maybe we do like them, but there might be other very important reasons. And one example I want to talk about is if that individual is receiving Medicaid, right? So if an individual is receiving Medicaid, they need to keep their assets and their income below certain threshold amounts. So that means in certain cases, they need to make sure that their assets stay below $2,000. So if you have an individual who's receiving Medicaid and now they have just inherited a large sum of money, now they're going to be kicked off of Medicaid, right? We see this happen. Sometimes we have two a husband and wife, and one spouse may be in an institutional setting. Perhaps they need some long-term care in a facility, and the other spouse might be in a community setting. And that spouse that's in that institutional setting may be on Medicaid, right? And if their spouse who's in the community passes away and they don't have a plan in place, it could turn around and jeopardize all of the supports that they have right now. So without that plan, we have no control over how our assets are going to pass. We also don't have control over who is going to be in charge, right? And there's a lot of tasks that need to happen. And we're going to talk about those as we go through the presentation, but this is a job, right? Handling somebody's estate is not just, hey, I was the person that mom and dad loved the most, but it's a job where you need to do things like closing out bank accounts, accounting for money, doing an accounting, filing a final tax return. So there's a lot of financial pieces in handling somebody's estate. And we want somebody who has those skills, that has the ability to be organized, to keep track of things and take care of what needs to get done. but we also need to make sure we name the person who is going to be also have some of those soft skills, who's going to be able to deal with the beneficiaries who are grieving, right? So you have somebody pass away, the person who's handling the estate. If there's a will, that's called an executor, the person who's handling the estate. But without a will, that person's called the administrator. So that administrator handling the estate may not be the best person for the job, right? So these are things that we want to think about. So without that plan, all of this is up in the air, right? We don't know what's happening, how things should go. We don't know who's in charge. And then it's a rush to the court and a fight sometimes between family members on who's going to be taking the lead. Now, looking at the will, and we're going to start with the will, and we're going to work through some of the other documents. I'm going to give you an overview of what a trust is. We're going to talk about some of the documents in place while you're alive. But a will is what I'm going to call an instruction sheet, right? So it's a set of instructions that tells your family, tells the court, because it does get filed in the probate court, what should happen next after you have passed away, right? And so this is very important because it says who is going to be in charge. It's going to name that executor. It's also then going to say, this is how I want my assets to pass. Maybe I want everything to go to my spouse, and I want them to have the benefit of our joint assets. Maybe I have a blended family and I have kids from a prior marriage, and I only want some money to go to my spouse and some to go to maybe my children. Your will is going to be that instruction sheet. It's going to name that executor who's going to handle those things we mentioned, the funeral, your taxes. It's also going to show handle your bills, making sure that your final debts are paid. If you have outstanding medical bills, it's going to take care of those. And let me just adjust here my PowerPoint presentation to make sure that it might be a better view here, so that way everybody can see. Oh, there we go. All right, so let me just get back to the slide that we were on. And here, okay, so talking about so we're going to talk about who's going to, thank you, who is going to wrap up your final affairs. They're going to make sure they pay your bills, your final debts. This is very, very important. A lot of times people don't realize when you pass away, your bills still need to be paid, right? And that's the responsibility of your estate to handle taking care of those final bills. Now, one thing that I want to be crystal clear about, we're going to talk about this. Your will, I call it an instruction sheet. It is the instructions for what is in your probate estate, right? And that's very, very important because we also have other assets. And I'm going to give you the example. We have other assets that are not part of your probate estate. Those are things like life insurance. Maybe you have a retirement account. Those financial accounts are going to have a beneficiary designation on it. That means that beneficiary designation is what controls those accounts. So when we talk about what's going to happen with your will is going to control your assets, such as maybe your house, right? Normally on a house, you might have a husband and wife, so it might be with rights of survivorship. So whoever survives has the house. But then when that second spouse passes away, the will control what happens to that house. Bank accounts. It's going to control your personal property. What are those items that you have that are personal and important to the family? So that's what your will is going to control. And I bring up bank accounts, and I just want to mention, this is a hot button topic, right? We can talk about bank accounts again for hours on this, but a lot of times folks will say to me, well, I can leave a bank account payable on death to, designate somebody to be payable on death. And yes, you absolutely can. And that is a great way to get that money to a person very quickly after you've passed away. Couple things we need to keep in mind with some of these payable on death designations is it doesn't mean that it can't be used to pay bills that are required as part of your estate. We still may have some tax waivers to do, things that'll have to get taken care of, so that those assets may end up getting clawed back into your estate. But one thing that happens often, I get this question a lot, is should I just name my son or my daughter or whoever it is on my account as a joint owner with me? And emphatically, I tell people no. And there's pros and cons for it. People will say, hey, it makes it easier for my child to access money if something should happen to me. But in all aspects, adding their name onto that account means that that account is equally theirs, right? So it is their asset. That means if they file for bankruptcy, if they are in an accident and there is any judgments that are brought against them, it's their asset as well. On the flip side, it is their asset in a positive way, but maybe not a way that they necessarily want it. Example I had is I had somebody come to me and say that they named their daughter, their grown adult daughter, on their bank account with them. Grandma did, and the grandchild was now applying to colleges, and because that was considered an asset of mom's, they were not eligible for certain loans, right? So you take the bad, the good and the bad with it, and it's really not mom's asset, right? It's really not hers, but because in all legal aspects it's listed down as hers, it's treated that way, right? So in some cases, I talk to folks, we sit down, we talk about what assets they have, how they are titled, who owns them, how we want them to pass, who do we want to receive this asset, and we figure out the best way to do so. So your estate is normally going to have, in your probate estate, a house, it's going to have your bank accounts, it's going to have your personal property, and then any other property you might have, cars, if you have timeshare, anything else like that is going to be covered under this, unless it has a beneficiary designation like life insurance and retirement accounts. The other important piece with your child is who's going to, or your wills, who's going to care for your children. You have minor children. You know, we're focused on the elderly tonight, but I just want to mention this. If you have minor children, you want to name who's going to be their guardian. But oftentimes I have families that have an adult child who is disabled and under guardianship, right? So, you know, I have individuals that have families, you know, with a child with maybe Down syndrome or autism, and they can't live independently. That still needs, they still need to think about who is going to care for them if they cannot. And that information is definitely going to go into the will. Right. Moving on to the next slide here. Let me just get this here. Trusts. Oftentimes people ask me as part of the estate plan, do I need a trust? Or I was told, I read by Susie Orman in a book, that I need to have a revocable living trust. Oftentimes having a trust is going to depend on your circumstances. It's really going to depend on what's going on in your family and the reason for the trust. So there are thousands of different types of trusts out there. I'm going to talk about the two categories that they fall into, but I tell people we use a trust when we have a specific goal that we need to accomplish, right? In one example I'm going to use is if I have a child, back to the child with Down syndrome, we're going to use a special needs trust, not to jeopardize their benefits. Now, we can use a special needs trust for an individual that has a disability, that as long as that individual is under the age of 65, right? So we can also use it for some of our elderly parents, for some other people, but we really need to have that purpose for that trust. Another purpose for the trust is when we have blended families, we want to make sure that we have assets that can be available for both spouses during their lifetime if something should happen to one spouse versus the other. And then we might want to have it breaking down. So we're making sure we provide for children of maybe prior marriages or blended families of both marriage. So we would use trusts in order to accomplish those goals. I often use trusts a lot for minor children, right? We want to make sure that we have somebody overseeing money, right? If a minor child is going to inherit money. So we generally, courts are not going to pay out money in an estate to a child that's under 18 unless it's going to be paid to their guardian or into a trust. But even at the age of 18, sometimes children aren't responsible to really making good decisions. So we'll want to think about, should we keep money into a trust until they've reached the age of 25 or maybe till they reach the age of 30, especially if this is large pots of money, right? So we might want to make sure that we have that oversight for there. So trusts are created. There's three parts to a trust in order to create a trust. Number one, you need the grantor, the person that's creating it. So that's part number one. Number two, you need the beneficiary or beneficiaries, could be more than one person. That's who's going to benefit from that trust. And the third piece of a trust is who's going to be the trustee. So there's two broad categories of trusts I'm going to talk about. There's revocable trusts. There's trusts that you can put in place. You can put assets into that trust once they are created, and you can take them out and you can dissolve the trust at any time. You can put them in and out, doesn't matter how many times you want to do that. An irrevocable trust is once you put money into that particular trust, you cannot take that money back out of that trust, and you cannot change a lot of the decisions with that trust. Now, people are like, well, why would I ever do that? Why would I set up an irrevocable trust? Well, if somebody is receiving Medicaid, Sometimes we may need to set up an irrevocable trust to put assets into a trust. It's considered a complete, if they're receiving Medicaid, we can't do it as a Medicaid planning tool. Sometimes we use what's called a Miller trust or a qualified income trust to help somebody become Medicaid eligible for using that with the income that they receive into it, and it's irrevocable. Once that income gets paid into it, then it gets paid over for the services that they need going along. If we're doing Medicaid planning, sometimes we will think about transferring money, transferring maybe a house into an irrevocable trust. But the key part, if we're doing this sort of long-term Medicaid planning, there's a couple key things we need to keep in mind. Is number one, Medicaid continues to have a 5-year look back. That means Medicaid is going to look at what you have done with your assets over the last 5 years. So if we put that house into that irrevocable trust today, that means you cannot apply for Medicaid in the next 5 years, or else we're going to have to undo everything. Number two, if we're putting it into an irrevocable trust, that means it is irrevocable. Once it's in there, it's there. But you also have to give up control over it for it to be a completed gift to the trust, right? So if we are using that type of trust for long-term planning, we want to think about who do we want to name to be our trustees, right? And that trustee is going to be the person who's in charge of overseeing that asset. If there's taxes to be paid, they would pay taxes. They would manage the money if it's money that's invested. So with trusts, I tell people, when we do the intake, we want to talk about what assets they have. We want to talk about what goals they have. What are we trying to accomplish? And in some cases, a trust is appropriate, but in most estate plans in New Jersey, having a will-based estate plan with a couple other documents we're going to go through in the next couple slides, that is sufficient enough for most families to protect them. Now, we talk about administering a trust, and I just have a couple more slides on trust so we understand them. We do need to have a trustee in place at all times. This can be an individual. This could be a corporate, so some banks have trust departments. Sometimes there may be co-trustees, and this is a very similar question with co-trustees that I get to maybe co-executors of an estate. Should we name two people to be in charge of handling our estate or handling our trust? While the answer is maybe, because it might depend on what your goals are. Maybe we have somebody who's really good at the numbers game, and they might be, an accountant, or they might be financially savvy. And we might have somebody who has good soft skills, who might be able to interface very well with our beneficiaries, who might be grieving, or maybe it's a trust that has to last for multiple generations for like our grandchildren. So we want to make sure that we have somebody who's good, who knows the grandchildren well. But the problem is with co-trustees is banks and financial institutions, they want to know who's in charge. And when you have two people that are equal, they don't know who should be calling the shots, right? So what they end up finding is that a lot of banks won't allow them to open up accounts for the trust, or won't allow them to open up estate accounts if there's co-trustees. So that these are things just to keep in mind when we're making these decisions. Sometimes people will say, I have two children, so I want to name both of them equally, but they might end up having a lot of hurdles when they're trying to get the job done for you. Some cases there's a nonprofit. This is for an individual with a disability. There's a nonprofit in New Jersey that could serve as a trustee. And then in some cases you might have a combination of these things. And I say combination because you might have an individual appointed as a trustee. And then I see language in trust where it says, hey, if my estate is over $600,000, or if the trust is over $600,000, I want to add a corporate co-trustee on to oversee the investments, right? And so what is a trustee doing is they're investing the money or investing that asset, making sure that it's taken care of, approving the spending, right? So if spending needs to happen from the trust, they need to oversee that. They need to make sure if the individual that's a beneficiary of that trust is receiving any sort of government benefits, they need to make sure it does not jeopardize the benefits they have in place, right? So it is a very important job that they have as a trustee. They need to do annual accounting, so they need to do a tax return, because if you, depending on the type of trust, if it's a revocable trust, that's connected to your personal taxes. But if you set up an irrevocable trust, it has its own EIN number, it files its own tax return, right? And these are just, like I said, these are big broad strokes so you guys understand these concepts, but there's, a lot to think about. People say, how do I fund a trust? Or even how do I fund my estate, right? So, and I tell people, mom and dad's estate plan, grandma and grandpa's estate plan, sometimes it'll say in their will, the money is to be paid over into the trust, right? I have a family right now, they had paid money into what they call a generation skipping trust. So grandma passed away and it skipped mom and dad's generation, and it's being set up for the grandkids and the great grandkids, right? So her estate said, listen, I want this money and I want it to last. And so therefore I'm going to put it there. So that way, by the time my grandkids are old enough, that pot of money is there and available for them. Sometimes folks will have a life insurance policy and they will direct that life insurance policy to pay over to a trust. Example is you would name the beneficiary of that policy the trust, right? So you need to make sure that it's very specific and you are naming a trust that's already set up. Sometimes I see people name, say, hey, I wanted to go to the ABC Family Trust, and they've never set up the ABC Family Trust. So it's important that we have that in place if we are going to direct assets to pay over there. Same thing with retirement accounts. We might make them a beneficiary of it. Sometimes people receive settlements. They've been in a car accident. We can use that money to establish a trust, or if they have their own assets, right? And they want to go ahead and put that into a trust to preserve that for whatever reason that may be. And then I say the unexpected inheritance. Sometimes you have somebody who passes away and you've received something from them. We can always use that to fund a trust. So I want to shift a little bit away from the will planning and the trust planning over to documents that we talk about putting in place while individuals are alive that are used to help support them, right? So the main one that we do is a power of attorney document. This is used to allow someone to make legal and financial decisions on your behalf. There's different types. I'm going to talk about those right there in a second. There's a durable, there's a springing one, there's limited powers of attorney. But this document, what I like to equate this document to is to a key, right? A lot of times people say, well, I'm signing this power of attorney and I'm giving my son or my daughter the access to make legal decisions for me, financial, to sell my house, to access my bank accounts, to close them out, to do all of these things for us. Now, number one, it's important that we name somebody to do this, because if we're incapacitated, we do not want to go to the court. We do not want to have our family members going to the court to say that we need a guardian, to have the court declaring that we're incapacitated, and then to have the court overseeing them accessing our assets, right? So I have a guardianship that's ongoing right now. Grandpa passed away. They had no documents in place. Grandma, she needs memory care, so she has some dementia. They have no documents in place, so we needed to go to the court to have a guardian appointed for grandma. Now that is her two sons. They're both appointed as her co-guardians. But now we have to go back to the court and say, yes, we need to sell grandma's house. We need to sell grandma's house because we need to provide and pay for her to be in this memory care facility, right? And so what we need to do is we need to put documents in place so we can allow our family to handle these things for us while we are still alive without running to the court, right? The power of attorney, this is a very, very strong document. We need to make sure whoever we are naming, we trust. But I equate this to a key, and I tell people, if you trust that person enough to give them a key to your home, to go into your house, maybe to water your plants or to feed your pet or to do whatever that might be. Hey, you have my key in an emergency, and you are trusting them not to go in your house and ransack your belongings and steal your TV or steal your bank accounts, then you trust them, right? So we have to look at it that way. So you're giving a person trust. I understand it's a little bit scarier when we talk about it in legal terms, but we still need to trust the person we're naming. Now, if you tell me, I would not give this person a key to my house, I'm going to say we are not naming them in this document, right? So that's going to be our sort of our threshold. Oftentimes what I see is we name a spouse first, and then we name a backup to that spouse, right? So who is our trusted person who we would want to write checks out of our account or make sure that the taxes get paid. So different types of powers of attorney. You have probably signed them during your life and didn't even realize it. If you ever bought a car at a dealership, you probably signed a limited power of attorney to allow the car dealer to register your car for you, right? So we've signed them in limited circumstances. A limited power of attorney is is designed for a very specific purpose. It probably has an expiration date, and that person can't do any more than what is identified in that particular document. There is a durable power of attorney. And this is a document that I use 99.999% of the time. This document is in place from the date that we sign it, that durable power of attorney, and it continues until you revoke it. Now, the other option is a springing power of attorney. And that document can spring into place if you are incapacitated. Now, I do not like that document because it creates a lot of challenges with financial institutions. And I'm just going to walk through the example is you have a springing power of attorney. You are now incapacitated. You're in the hospital or you're in a rehab facility, and your son or daughter is going to go to the bank because they're going to make sure that your utilities are getting paid on your house until you're well enough to come home and your taxes are getting paid. And they go to the bank with this document and the teller says, well, I don't know that she's incapacitated. I don't know this. And then you give them letters from the doctor and they're like, well, I'm not a medical professional. We need to send it to legal. Well, and then it goes to their legal department. And then you go back and forth. Now, at this point, it could be 3 months, 90 days sometimes that legal is looking at it, asking for more information. And that doesn't allow the person to actually use it in that moment why we set it up for, right? And so people think that it's a safer way to go because it sort of has a safeguard in place. But unfortunately, that safeguard becomes problematic. So the other piece is, and I mentioned this, if you're a parent of young children, you want to think about this for yourself. If we're the guardian for somebody else, so we could be the guardian for another adult. Maybe it's our spouse who's incapacitated, or if we have somebody that has a disability and we're their guardian. If we can't act for ourselves, we also can't act for that other person. So we need to think about sort of delegating that temporary guardianship power if something were to happen to us. So we could use these documents to do so, to make sure that if we can't care for ourselves, they are also still provided for if we're responsible for other humans, right? So that's important to think about when we're doing this. Now, this is the legal and financial side. Now I'm going to flip over to the healthcare and the medical side, right? So we want to think about, sometimes you'll hear the phrase medical directive. So we want to think about if we can't make a medical decision for us, who can make that decision, right? So sometimes you'll hear the phrase healthcare power of attorney. I tend to use that phrase because it's pretty easy to understand that it's healthcare and we're naming a power of attorney for it. Hospitals will sometimes use healthcare proxy, which basically proxy means somebody who's standing in for you. And all you're doing in this document is you are naming who can make healthcare medical decisions for yourself if you cannot, right? And very, very important is as long as you are able and capable of making a medical decision in all aspects, doctors will defer to you on that decision, right? So this document doesn't even come into place until you can't make medical decisions for yourself. Some things that I've seen during COVID, people that have documents in place already, during the COVID timeframe, we weren't allowed to go into the hospitals, we couldn't go into doctors' offices. So I started doing, as an example of how things change, I started putting cell phone numbers in my documents so doctors knew who to call to reach out to that person, right? So little things that have happened over time we have to change and adjust to, but we want to make sure that doctors know who they can reach out to if there is a medical emergency. If we do put an estate plan in place, what I tell people is we want to make sure that their primary care doctor their primary care doctor has a copy of these documents on file. I think it's just a good precaution. You put an estate plan in place, spend a bunch of money doing that. We want to make sure that the key people that need to know this information, and that's one of them. Your primary care physician or the physicians you see day to day, let's make sure that they have these in their files. I had a question come into the chat. Can a durable power of attorney be used if they are not incapacitated? Yes, absolutely. That's the durable part, right? So that document stays in place regardless of incapacity, right? So it is just used for convenience, right? So it's not convenient in the winter for grandma and grandpa to go to the bank, or not convenient for them to run down to City Hall and pay their taxes. Then we have that document in place that allows us to do that on their behalf. And there's other pieces that people say, who's going to make these decisions for us, right? I talked about trusting that person. When we name that person under that durable power of attorney, that legal and financial one, to make these decisions, we have to think, how is it going to be used hand in hand with the person on the healthcare power of attorney, right? Because you go into the hospital, or you're going to a rehab, they want to know, A, are you there because you medically need it? But the first thing they really want to know is, how are you going to pay for this? Do you have insurance? They're going to want to get their money. So if we have somebody doing that financial piece, we want to make sure that they could talk to the doctors on some level. So I also will suggest, sometimes people will say, listen, my niece is a nurse or my daughter's a nurse. I'm going to name her as my healthcare decision maker, but my son, I'm going to name him on the financial piece. I will probably put both of them on the HIPAA release. I'll do a standalone HIPAA release, because that way, if he is paying a medical bill, he can talk to the doctors, right? So we kind of want to make sure that when we're putting this plan in place, we not just think about who's the best person for the job, but how are these jobs going to overlap and interact with each other? Well, that was a great question that came in the chat. Thank you for that. Very much appreciated. Next document that we do is a living will. Now, sometimes you will see some attorneys will draft the whole medical directives, and it'll all be in one document. So if you currently have documents in place, or mom and dad have them, and they're like, wait, there's just one medical document, don't be freaked out about that. I tend to do them as standalone different documents. That's just my personal preference. There's no right or wrong to this, but it helps people understand what they are by doing them as standalone documents. So you'll sometimes see one medical directive that has the healthcare proxy, healthcare power of attorney, and the living will in it. So living will is what is used for your end of life decisions, right? And this is what we think about when people are like, I don't want to be a vegetable on a ventilator. If the condition is terminal, there is no hope, there is no cure, and death is imminent, right? So that's the key piece, is death is imminent. Then what are my wishes? All right. Now, there is something called, a POLST, or, and it's a physician's order for life-saving treatment. That is a very specific it's a very specific order by your doctor that is used after you consult with your doctor. If you have a terminal illness, that doctor can write that order that says, listen, we're not resuscitating, we're not, and that's a little bit different, right? That is limited to a particular hospital or a particular care for a certain doctor. What this document is, the living will, is this is telling your wishes, right, to the doctors, telling your wishes to your family, right? So your family is not sitting there in the hospital saying, wait, what would mom and dad want? Would dad want to still be in this condition? What if there's a possibility? If you spell it out in this document that says, listen, if death is imminent anyway, I want to die naturally, I want to have pain medication to be comfortable, your family is going to have sort of that peace of mind knowing that they are making that right decision for you. Now, what I'd like to put in my document is that if there's any gray area or there's any question, we state in the living will, if there's any question whatsoever, you refer to the person that I have named as my healthcare power of attorney or my healthcare proxy. That is a living, breathing person that has a brain. We have named them because we trust them. And so if there's any question about what should be done in an end of life situation, please defer to that family member, right? That sort of gives people comfort, because there's a bit of a scare that hospitals or doctors are going to follow these documents robotically. And while they do follow patients' wishes, this helps them to know that they do consult the family or the individuals that are named for those decisions. All right. So, and I want to talk a little bit again about the assets outside of probate. And I mentioned this early on, but this is very, very important. Talking about why we care about them so much, right? And that's things like the life insurance policy, things like your retirement account. Number one, people will come to me and they'll say, listen, I want to make sure that my son receives everything, and if not, I want it to go to my grandchildren. Except on a life insurance policy, they will only name their son. Well, if their son is not alive, it's going to go into their estate. It's not going to go to the grandkids. Now, maybe the grandkids are the beneficiaries of the estate, but we care about them because we need to make sure that all of these documents are consistent with our wishes, right? So we can't say, I want my spouse to receive everything, but yet have, outdated beneficiary designations. Example I like to use is my dad passed away back in 2016. My parents were divorced, and when my dad was hired by the police department, only 2 out of the 4 of us were alive. Well, my dad never updated anything. So when he passed away, only 2 out of 4 of his kids were listed as beneficiaries, right? We did the right thing. We split it amongst the 4 of us, but not every family is going to be that understanding and to know that this is what mom and dad would want. The other piece that I want to talk about, and I can't stress this enough, is life insurance policy is paid to that beneficiary. A lot of times people will say, I'll ask, do you have funeral arrangements made? Have you prepaid funeral? And they'll say, I have a life insurance policy and I've named my son and they're going to take care of it. I can assure you that I am now almost 2 years into a litigation where 4 children received the life insurance policies and only one of them used that towards paying the funeral. So we currently have a funeral bill that is outstanding. 3/4 of it is not paid. And we have 3 of the children who have taken off with the money who are doing their own thing about this. So if you name a beneficiary to receive that life insurance, that is who is going to receive it. We can hope that they do the right thing. We can hope that they pay it over to the funeral home. And a lot of times people do. But there's no guarantee. So if we want to guarantee that our funeral is taken care of, that it has been prepaid, what I tell people is you go to the funeral home. There is what's called a funeral trust or a burial trust or a prepaid funeral account, and you can set that up. In most cases, we can have that it's considered revocable, meaning that if you want to take money back out of it, or you decide you want to move to another state and you want to move it to another funeral home, perfectly okay. But we can set that up, and then we are guaranteed to know that our final affairs are taken care of. We don't have to worry about the life insurance policy being paid there. So that's just something really important to keep in mind, is that there are some life insurance policies that can be assigned over to a funeral home. So I want to just make that clear. There are some that you can do an assignment. If mom and dad pass away, hey, we're going to assign this over to the funeral home, and then that life insurance will pay directly out to the funeral home. But as the beneficiary, you need to do that paperwork, that assignment to make that happen, right? So it's just really, really important that we're talking about these assets out of probate. We understand what happens to them legally. It doesn't always match up what we want to happen with them. So we make sure that we have our plan in place for everything that we have in our life. All right, this is a big screen here, and this is all of the other things. There's a lot of other things to think about that we really need to think about when we're planning our estate, right? So not all of these are necessarily legal documents. Some of them are, some of them aren't, but they are equally as important. Number one, the funeral instructions, right? Some people aren't ready to think about their final affairs, right? They don't know what they want. It's a difficult thing to think about a world where we're not here. Sometimes it's hard to imagine that. And I understand that. I tell people that you don't have to make decisions today. What I normally do is give them a worksheet, right? It's a couple pages long of things that they can think about. Maybe where do you want to be buried? Is there a family plot? Information that your family might not know for your obituary, right? So a lot of times there might be places that you've worked or different organizations you were a part of that are really important that you would want mentioned. And your family might not know that, or in that moment of grief, they may not remember that, right? So this worksheet kind of helps them with that. If you do decide to make arrangements directly with a funeral home, they have similar worksheets. You can either give them a copy of this or you can fill out their own. Burial instructions. Do you want to be buried? Do you want to be cremated? If you want to be cremated, that seems to be the new popular thing right now. What do you want to happen with your ashes? Right? So a lot of times people are like, I want to be cremated, but they haven't thought about then what, right? Do you want to be buried with another family member just because you've been cremated? Do you want to sit on somebody's fireplace, maybe on the mantle? But you need to know what that next step is for what's going to happen to you when you're not here. I did have somebody who is slightly misinformed, who said, well, you can just leave my ashes at the funeral home because after 5 years, they will dump them in the garden and it'll make very nice flowers. So I assure you, funeral homes do not do that with people's ashes, but we still need to make sure we have a plan in place. The other thing is letters of personal property. A lot of times we have small personal items in our possession that we may want to go to a specific person. This is a legal document. So in your will, there's a paragraph that I put in there that says, if I have a personal property memorandum, you are obligated to follow it, right? And so it's clearly spelled out in your will. You're telling that to the executor, if I have this. And then I usually draft a template document for my clients to have with their will if they choose to use it. What I see clients using that document for is maybe they have family photographs, right? And they want to make sure they go to a cousin or a niece. Maybe there's a family heirloom. Maybe your grandfather was in the war. Maybe there's a flag. Maybe there's medals, and you want to make sure that that goes to a particular family member. We can use that document to detail that out. Sometimes you have china, you have other things that are important. We can use that document. So this is for personal property, tangible property that we have. We can do this instruction sheet saying who it's going to go to. Care instructions for a child, and I would say this also, care instructions if you're caring for another adult, right? You might be caring for your mom and dad, right? And I use the case here, care instructions for a child, but if something happens to you, what then happens to them? What doctors do they see? What medications are they on? Who do you call for an emergency for them? That's all very important information. If somebody's stepping into your shoes, they may not know that information. I have a very tragic situation right now. Mom died about 6 months ago. Dad died about a week and a half ago. They have 2 adult boys who are under guardianship because they have a disability. So these are 2 adults, and there's a family member that's now stepped in to care for them, but I had a phone call with her today because she doesn't know what prescriptions they take or how frequently they take them. And so it's hard for somebody to step into your shoes, even if we're caring for our spouse, to know what we're doing to take care of them. If you are a guardian for somebody else, whether it's a minor child or an adult, if you are their guardian, think about having a successor guardian in place, either in your own will. This is who I want my backup to be if something should happen to me. So we want to put that in place. Or sometimes we might want to add them on through the courts as a co-guardian, right? We like to avoid guardianship. Sometimes we can't. Sometimes we need to do the guardianship option. But if you are a guardian, who is going to be your backup if you are not here? Lists of online accounts and passwords. I prepare for my clients an entire binder, right? So a lot of times people will call me and say, hey, I just need a will. And I'm like, yeah, sure you do, but we'll talk when you get here. And I talk to them because there's a lot of information that they need to pass on, right? So I do a binder for them. And in there's a tab of personal information is all it says. And I tell people, do a list of your online accounts or a list of your passwords. Put a copy of that life insurance policy behind that tab so they know the account numbers. Do a list of where you bank. I have clients that come to me and they'll say to me, well, I'll say, all right, let's talk about your bank accounts. And they'll be like, well, I have accounts at 7 different banks. And I'm like, okay, well, let's write them down. Let's talk about them. Why do they do that? Because they were chasing interest rates. They have a CD here. It was doing very well. There was another promotion. They did an investment over there. So there's reasons for it. But now their assets are divided up. So if somebody needs to step in for them, they need to know what to do. I want to mention this, but I just mentioned CDs. A lot of times folks will have a beneficiary designated on a CD. It'll say, hey, if I pass away, this is who to pay it to on a CD. Oftentimes what people do is they roll over that CD after it matures, a 6-month CD or a year CD. If you do not renew that beneficiary designation, when you roll over that CD, that does not roll over with it. So we've learned the hard way with unfortunately, somebody who's passed away. She kept rolling over her CDs, but she never gave the bank instructions to continue with that designation. So that was a little bit of a problem. And information regarding safe deposit boxes. I know a lot of people don't use them, but if it turns out that you have one, we need to know what's in there, even if it's nothing, right? And I had one recently. If Dad passed away, Dad had a safe deposit box, but nobody had the key for it. So the son was appointed. He's the executor now. He lives up in Boston. He comes down for the weekend. He goes Saturday morning to the bank, and he gets the Wells Fargo, and they're like, you need the key, because the bank has one key. They need the other key. He doesn't have the key. So he finds out they need to schedule a time for a special locksmith to come there to drill it out on a different date and time. So we go through all of this, we schedule all the paperwork, that takes another couple of weeks. He comes back down from Boston, he goes there, they go through all this hoopla of drilling it out, and the box is empty, right? So, unfortunately, if we have them, we may have them and say, oh, I'm not ever going to use it, but let your family know that, or let your family know where the key is, so that way they don't go through the trouble of saying, does grandma have a whole bunch of gold bars hidden there? Like, I need to go through to find out. No, we need to make sure that we know. And there is some level and I recognize this, and I don't really have a good solution, there is some level of risk in putting all of this information in one place, right? Because you're putting that information together. But what I tell people is to be smart about it, right? So maybe you don't want to necessarily put that list of passwords where you put all of that information for your banks and your bank statements. But what I do want you to do is make sure that the important people that need to know this information know where it can be found. Right, so that's the important piece on that. So these are other things that we need to think about. The other parts of your estate plan, sort of that big picture planning when we're putting this together. Long-term care planning, a lot of information to put into the last 5 minutes of this, but a lot of times people will say to me they have Medicare. Medicare does not cover a stay in a long-term care facility, right? So it'll cover, I believe, up to like 60 days. Oftentimes, a long-term care facility can cost anywhere between $5,000 if you don't need a lot of care per month, all the way up to $15,000 and then some per month, right? So long-term care is not cheap if you need it, right? And unfortunately, sometimes our loved one reaches the point where having care in the home is no longer feasible. Maybe their medical needs are beyond that, or maybe there's no nearby family to care for them and they need to go into a facility. Medicaid is what we call needs-based, right? So Medicare is an entitlement. So you retire, you are entitled to be on Medicare. Medicaid, you are not entitled to be on Medicaid. That is only for people that have income and assets below a certain amount. So a lot of times people will say, I need to give everything away, or Medicaid's going to take it after I die, the government's going to take it. That is because it is a program that is only available for those people with limited resources. So you need to make sure that you meet those requirements in order to be eligible. Now, oftentimes what I see with my elderly clients, what we have to do is do what's called a spend down, right? So they might have a house, they might have a lot of money in an account, but we need to do a plan in place as to how that money is going to be spent. Oftentimes it's spent on their own care first before we can then do that application to Medicaid. Right. And so just like people to understand that there is a difference between the two, the Medicaid does have those requirements that somebody be under those income and asset limits. And it matters. And so like, I'm not going into the details with this because there's an entire chart. It matters whether it's a single individual. It matters if it's a single individual with, let's say, husband in a nursing home and the wife still living in the house. And so there's different amounts based on 2 people in a nursing home or 2, so it varies based on their scenario. But generally speaking, their income can't be more than couple thousand dollars per month. And their assets need to stay below that $2,000 mark, which is very hard to do sometimes. So oftentimes I tell people who are younger or have that opportunity to think about long-term care insurance. It's not cheap, I know that, just something to think about in the back of your mind. There are certain policies, and I like to mention this, there are certain policies that are backed by the state of New Jersey that say if you pay for long-term care insurance and your long-term care insurance covers, let's just say hypothetically, 2 years in a facility, that if you use your long-term care insurance for the first 2 years and you still need care, we will allow you to become Medicaid eligible, and we will allow you to exempt more assets because you paid for your own care first through long-term care insurance, right? So there are benefits to buying long-term care insurance. It does help the family, but it is important to know that. If you are thinking about preserving your family assets, and you do think that down the road you or your spouse is going to need Medicaid, you need to start that planning well beyond, like you need to be at least 5 years before you're going to need Medicaid, right? So a lot of the laws have changed over the last couple of years, and Medicaid has made it very, very hard and difficult to use some of the exemptions that used to be in place, or some of the tools that we used to have in order to make somebody eligible. Really right now, we just need to make sure we're planning early in the phase. And in some cases, we may be able to maybe transfer home to a child. If there's somebody we want to transfer the home to. One very, very, very big exemption that's still in place that I'd like to mention to people is that if they have a child, you have to check all of these boxes. If you have a child who is providing you with care and living in your home, right? All of those things, and you need Medicaid, you're able to transfer the home to that adult's caregiver. And that would be an exempt transfer, right? So they need to be providing you with care for the last 2 years. They need to be living in the home. So they can't have their own home and just be staying over there sometimes. Like that needs to be their primary residence day in and day out. If they meet all of those boxes, then we can transfer the home to them. Now, oftentimes families don't want that because they're like, wait, I have 4 kids. I don't want it to go to this one child. It just happens to be one of the exemptions that's still out there. It doesn't work for all families, but in some cases it does work. The reason why the thought process behind that is Medicaid is basically saying thank you to that child for being the caregiver, right? So they're saying thank you for providing care for this individual for the last 2 years. And therefore we are going to thank you for it by allowing this transfer to be exempt, right? So that's sort of the thought process. But these are all, again, there's a lot to unpack with, the Medicare and the Medicaid planning for it, but this is just to give you an overview of things that you need to be thinking about if you are caring for somebody who is likely to need these, and to make sure that we get in on that planning process sooner rather than later. So last slide that I really want to cover tonight before our time is up is when to update your estate plan, right? I tell people annually you should take a look at it. Number one, make sure you still like the people that you have named in your estate plan, right? Make sure we like them. Number two, make sure we still trust those people, right? So life happens, things happen, people change, and we've named them because in that moment we trusted them to do a particular job. And maybe today they may or may not be that best person for that job. That happens. It's okay. We want to update your estate plan anytime you have a major life event, right? You get married, you get divorced, your spouse passes away, you have new children that come into your life, you relocate to another state, you retirement. These are all big things. Now, people say to me, well, what if I decide to move to another state? Technically, your will is still, as long as it's executed validly in the state where it was created, it's still good. It's still a valid will. However, every state has different laws, right? And so just because you've moved and you have a valid will, you should make sure that it complies with the current state's law. So example is in Florida. In Florida, probate is very expensive. I'm licensed New Jersey, Florida. So probate's very expensive. It's very timely. It's cost. There's a lot of oversight by the court. You have to file a lot of petitions. So in Florida, we do a lot of trusts. We set up a lot of revocable trusts to avoid probate. New Jersey, we don't have those sort of same concerns. So we don't necessarily have to avoid probate. We just need to make sure everything is in place for a smooth probate process, a different consideration. So if I have a client that's moving to Florida, I want them to have that trust in place to make sure that they're saving money there, because that could be very time consuming and costly. New Jersey, I don't have to. A will-based plan most often is going to be sufficient, right? So these are the types of things we need to think about from state to state. Also, you want to make sure that every 2 to 3 years you're sitting down with an attorney, because laws change, things change. An example that I use is 5 years ago, we weren't doing as much online banking, right? We didn't have things like 2-factor authorization where we get a little code text to our cell phone that we have to use to log into an account, right? So language in my documents now has things like digital assets. My executor or my power of attorney can access my phone to get that little code that they might need, right? So we need to give them permission for those things. That's how laws have evolved. I've had clients come to me that have cryptocurrency. So we need to think about how we're planning for those types of assets. These are things that have been unique, that have changed, that are unique. Documents like a power of attorney and the medical directives, the medical documents I talked about, technically they do not expire, right? They do not expire. But I will have uneducated tellers at banks that will tell clients that go to use these, this document's no good, it was created 3 years ago. Now, usually that then involves the client coming back to me sending a very strongly worded letter to the bank, it getting kicked up to legal saying, okay, we will tell them that it's still good, and now they can go about their business. But it does slow down the process. It makes people very upset. So what I tell people is, if you're coming in to sit down with me anyway, and we're going to go over and make sure everything's current, I'm just going to print out some new powers of attorney, medical directives. Even though we don't change anything, we're going to sign them and update them with a new date. So that way we have some current documents in place, right? So it's just a way of making sure that clients stay current with what they have. So every year, what I do is I send my clients a letter just to remind them, hi, it's been a year since you signed your estate plan. If any of these changes happened, reach out to me. If not, I'll check in with you again in a year, but it just keeps it fresh in their mind. Or I tell clients, anytime you do your taxes, that's a good time to do a self-review, because you're probably looking at your finances, you're taking everything out, you're digging out stuff from that filing cabinet. Well, go ahead, take a look at this, make sure it's current, and everything's in place. So with that, that brings me to the end of my presentation. I'm happy to stick around for any questions that folks might have that have joined us online. Again, I just ask that we don't put personal information into the chat, because I don't want that necessarily to be out there, but I'm happy to answer any questions. If I can be of assistance to anybody, that is my contact information, my website for my firm, and the phone number there. Please do not hesitate to reach out to me. I am happy to help. And again, thanks to the East Brunswick Library for having me out tonight. It's always a pleasure to come out and share this information with individuals in the community.
While we're waiting to see if there are any questions, I just thought I could mention to those of us joining us online, this is a series, and we are hosting the next program in the series on Thursday, November 16th. It is Health and Medical Responsibilities for Caregivers, and that will be also at 7 o'clock, again, in person and on Zoom. So please join us for that one as well if you're interested.
Okay, I did get one question in here. And the question is, if my spouse has dementia, can they still legally sign a durable power of attorney for health or medical so I can assist them, or will being their wife be enough? So unfortunately, just being a spouse is not enough. Now, hospitals and doctors will often defer to the spouse, because there's a hierarchy in the law as to who can make those decisions for you. And so they will defer to a spouse, and because that's the next, technically the next person in line. Now, here's the thing with somebody who has dementia. I often see this with individuals that have mental illnesses. They sometimes don't understand what's happening. And if they tell a doctor, no, I don't want my spouse here, or if they say, no, I don't want you talking to them, the doctors have to abide by their wishes, right? So it's really important to understand. So, at any point, they're there as long as they've agreed and they're okay with it, and the doctors have done so. With dementia, and anything that really impacts your cognitive thinking, what we look for as to whether they can still sign a legal document is, do they have capacity in that moment to understand what they are doing, right? And I think it's important that we understand that as people age and some of these health concerns come up, they still have periods of lucidity, right? So they still have periods where they understand what's happening. So as long as a person understands what they are doing and what they are signing and the nature of that document, we can go ahead and sign them. Do they need to understand every single legal term that's in there? No, that's my job to educate you, to advise you as your attorney, to say, this is what this document means. This is why you're signing it. And so you understand it. But in terms of, just because somebody has dementia doesn't mean that they necessarily can't sign that document. I do have an individual, excuse me, I apologize. I do have an individual who's very, very sick in the hospital, and he was having periods of lucidity, right? And most often what was happening is, as his medication would wear off, he would then have be able to think clearly, we'd be able to talk and communicate. But if they gave him medication to make him comfortable, unfortunately, it made him very drowsy, and he was really sleepy and didn't understand what was going on. So we needed to coordinate a time where we knew with the doctors and the staff that he was going to be up and awake. And it did involve a couple of phone calls back and forth, being like, hey, today's not a good day, for us to go in, for us to talk to him, make sure he understood what he was doing. And then we had those documents signed, right? So it is still possible. Again, it has to be very clear that we need to make sure that that person understands what they're signing. But being their spouse isn't going to be enough. It will get by. You will get by because, again, hospitals will defer to the person on the spouse, but you won't be able to do things like call up and say, why did we get this bill? You won't be able to say, you might be able to get information, but you're not going to be able to communicate with the doctors just by being the nature of the spouse in the way that you would with those documents in place. Another question came in. This individual says they have two parents where they need to start this process. They have a lot of information to start the conversation. Do I need both parents at the initial meeting? One is at the hospital going to rehab, the other is home, looking for the most efficient starting point to speak and communicate with them. So I recognize the fact that oftentimes this process gets started because a son or a daughter comes to me and says, my mom needs this, right? The reality is that when it comes down to mom and dad signing the documents, I need to make sure that these are their wishes. So I do welcome people starting that process with me, scheduling that meeting where I tell them, hey, this is the information that I'm going to need. I'm going to go over with mom and dad. But then I often ask to speak with mom and dad alone, either collectively as a couple, if that makes sense, depending on what's happening, or sometimes one-on-one without the children there. And I make sure that I speak to them. So that way I know that there's no pressure coming from that child, that they can openly communicate with me that this is what their wishes are. Because you mentioned that that is, or one of the parents, I don't know, that's that. I just assume that because of the case I have going on. One person's in the hospital going to rehab. I do make, if it's local here within Middlesex County, Monmouth, I do make offsite visits. I will go to, I guess that, okay. I will go to either the hospital or to a rehab facility. One of the biggest things that we need to coordinate is making sure that the staff is going to allow us in. Sometimes they have restrictions on how many visitors can come in. We need to make sure we explain to them, hey, I have an attorney coming in, this is the purpose. And then we also need to have usually 2 witnesses who are not family members, 2 witnesses sign the documents, right? And so I can always bring witnesses with me, but in some cases hospitals have, recent example, I had somebody in ICU and I could not bring 2 witnesses with me. I could bring one, but one of the nurses agreed to be our second witness. So we were able to get the documents done that way. So if this is something for a parent, contact my office, we'll set up the intake. What I normally do is like a consult, and you can give me things like mom and dad's, their names, the background information, and then I would meet with them to get who do they want in charge, who do they want to name for all of these decisions. And then what I'll sometimes say, depending on clients who might be elderly, they'll say, hey, I want to name, maybe examples, I want to name my niece, she lives in Freehold, and I will say, okay, is it okay if I talk to your son or daughter and get, your niece's home address and her cell phone number for these documents? More often than not, they say, oh yeah, that's great. And then what I'll do is I'll just make a note and then follow up. So we can kind of complete that process hand in hand to make it as easy as possible for the individual. But at the same time, I need to make sure that those meat and potatoes of those documents are their actual witness, their wishes. So great question. If I'm able to help, please, reach out. I'm happy to help with that.
Thank you, Tina, for joining us.
Thank you, everybody.
Thank you all for attending. I greatly appreciate it.